Hi, very good morning. This is a wonderful judgment under Customs Act. So I thought I will share this with you. It's a huge judgment of 155 pages. I am trying to shorten it without uh, without losing the essence of that judgment. The citation is Acme Hirgar Powertech Private Limited versus CBIC, Central Board of Indirect Taxes and Customs. Mover regulations. This is very important. MOOWR, mover regulations. That is manufacturing and other operations in warehouse regulations. It is about that. So, facts. The mover regulations provided for duty deferment on the import of capital goods and inputs intended to be used in manufacturing and other operations. Within quote, other operations, very important word. Within a customs bonded warehouse in terms of section 65 of the act. Pursuant to this, the petitioners moved application for grant of permission for solar power generating units. So they wanted to set up a solar power generating unit. They will produce electricity and supply. Licenses were granted by the customs authorities. The petitioner furnished a bond as per the requirement. Then the board issued one instruction. This is the instruction which is challenged by the petitioner. The board took the view that the regulation contemplates removal of resultant goods, that is within quote, upon fixation of a one-time lock on the load compartment of the means of transport in which goods are removed from the warehouse. So it said one-time lock has to be put in the while the goods are transported. That is the point. The board opined that electricity which is cleared for home consumption cannot comply with one-time lock condition, and hence it will fall outside the scope of mover regulation. This is what the board took this view. Board also took into consideration electricity cannot be deposited in the warehouse. Board held that grant of any permission under mover regulation to solar power generating units which were operating from the warehouses would not be in accordance with law, and therefore board gave a direction. The permissions granted are liable to be immediately reviewed and suitable action taken. That is the direction of the board to the customs officers. On the basis of the above instruction, the customs officers immediately issued notice to the petitioners. This instruction was challenged by the way of a writ petition before the Delhi High Court. One is validity of the impugned instruction. The subsequent questions are four. One is revenue requested the court to consider interplay between section 61 and 65. The first is validity of impugned instruction. Second is revenue requested the court to consider the interplay between section 61 and 65. Third is words in relation to appearing in section 65 should be narrowly interpreted. This is the view of the revenue. In relation to should not be given an expansive meaning, it should be narrowly interpreted. The fourth is if this is permitted, that is solar generating units are permitted to store in the warehouse and generate electricity, distortion in the level playing field will happen. That should not be permitted. That is the contention of the revenue. And the fifth one is the revenue insisted that purposive construction must be applied to the sections to interpret the provision. That is what the contention. So totally five. On the validity of the impugned instruction, Delhi High Court says the court held that section 151A is confined to broad policy directives concerning the working of the Act. High Court held that instruction to review all permissions granted clearly infringes upon the discretion conferred on the authorities to independently consider whether the licenses or permission granted were liable to either suspended or cancelled. Liable to be either suspended or cancelled. The power to cancel a license can be exercised by an authority only when it is found that the licensee has either contravened the provisions of the Act or the rules or regulations. The board's instruction clearly instructs the licensing authorities to proceed on the basis that generation of electricity is outside the ambit of mover regulation. This clearly travels beyond the power of section 151A. That is what the High Court said. The court further said, the power under section 151A is essentially concerned with ensuring uniformity in assessment practices and providing guidance to quasi-judicial authorities. So that is the power. You can give a uniformity in assessment practice and guide the quasi-judicial authorities. The scope and ambit of an exemption cannot be whittled down by issuing instructions. A circular which amounts to foreclosing or impinging upon the discretional judgment to be exercised by a judicial authority will not sustain. It includes a quasi-judicial authority. In the opinion of the court, the board cannot frame directions or issue circulars which would bind the subordinate authorities in discharge of their quasi-judicial functions or dictate or influence their powers. The instructions issued by the board clearly deter the licensing authorities from independently examining the contention of the petitioners with respect to generation of solar electricity under the mover regulations. High Court held that the instruction cannot be upheld based on the well-settled principles of administrative law, which abhor abdication of an independent decision-making power as well as a quasi-judicial authority being compelled to act under the dictates of a superior authority. Because of the preemptory direction of the board, the licensee faces an inevitable event of cancellation of license. The instruction of the board binds the authorities. Hence, the show cause notice is only a mere formality. The instruction issued by the board clearly amounts to a dictate to the authority to cancel the licenses and hence falls outside the principles of law. The Delhi High Court held that the board has trampled upon the powers of the licensing authority. From the show cause notice, it is clear that the authority understood the instruction to initiate proceedings for cancellation of licenses. This is what on the scope of section 151A. So the court finally said, board cannot dictate the quasi-judicial authorities. They can independently examine and then come to the conclusion. How can you dictate? You can only give a guidance. You cannot dictate the final outcome. So show cause notice itself becomes meaningless. That is what the court says. Then on interplay between section 61 and 65, the argument of CBIC was imported goods must form part of the resultant goods based on the input-output ratio fixed for paying the customs duty. Delhi High Court said a statute is generally framed in order to deal with myriad contingencies. Since the Act undoubtedly contemplates the import of non-capital goods, raw materials, etc., it had to necessarily provide for fixation of input-output ratio. This cannot be read as a restriction on the type of goods that may be imported and used in the course of manufacture. The court held that it is wholly incorrect to understand the scope of section 61 and 65 as being limited to those categories of goods which ultimately get subsumed in the resultant goods. Accordingly, Delhi High Court said the mover scheme is primarily concerned with the activity of manufacturing within the country as opposed to the nature of the end product that may be obtained. The focus of the scheme is manufacturing in India. The court held the mere fact that input-output ratio norms may not apply in the case of generation of electricity would not be determinative of the controversy. The norms are prescribed to take care of contingencies where a part of imported goods get consumed in the process of manufacture. The court held that the inapplicability of those factors in the case of generation of electricity is neither an oddity nor a legislative oversight. The High Court said the submission that capital goods must necessarily form part of the resultant goods is clearly misconceived. The court was unable to read section 61 and 65 as contemplating only such capital goods which themselves undergo a process of manufacture or those which may get consumed in the resultant product. The acceptance of that submission would, in the view of the court, would amount to placing an extremely narrow construction on the words manufacturing process or other operations. Other operations is very important. The words other operations must be acknowledged as representing the legislative intent to be the undertaking of the activity which may not necessarily answer to the attributes of manufacturing as generally understood. The court held the use of that expression other operations in fact is intended to expand the scope of the section 65. Then another argument we have seen in relation to must be narrowly interpreted. That is the argument of the government. The submission of the court says the submission of CBIC was that the words in relation to in section 65 must be read as intending to conceive of a manufacturing process in which capital goods or at least part of the capital goods gets subsumed in the resultant goods. This means that the expression in relation to must be read in an extremely narrow sense. Delhi High Court noted the judgment of Supreme Court in Doipak Systems and held that the phrase is in relation to is one seeking to convey comprehensiveness. In view of this, the Delhi High Court found it difficult to accept the view that the capital goods themselves must undergo a process of manufacture. The court held that as long as the imported capital goods are concerned with or relatable or referable to a process of manufacture, three things: capital goods are concerned with or relatable or referable to a process of manufacture or other operations, the activity so undertaken would qualify the statutory conditions placed by section 65 and they will qualify the test of eligibility. The court held that as long as the goods are found to have contributed or formed part of process of manufacture, then the qualifying criteria is fulfilled. Then the next submission of the government was it will create a distortion of level playing field. One, the domestic manufacturer, and the other, the person who imports and keeps the material, the capital goods in the warehouse and generate electricity. That is the argument. The argument of revenue was that the activity of solar power generation led to creation of inequalities between domestic manufacturers and the petitioners claiming undue benefit under mover regulation. In this connection, the court was requested to interpret section 65, which should serve the objective, that is, impetus to domestic generation of solar power. The court noted that activities undertaken by the petitioner are in aid of the objective of the country transitioning towards renewable energy. The argument was petitioners are driving undue advantage under the mover regulation, having established a solar generation unit, naturally with the aid of duty-free imports at a cost far lesser than the domestic producer. The court held the function of the court is only, this is important, the court held that the function of the court is only to interpret the statutory provisions in accordance with well-defined precepts of interpretation. The construction of a statute cannot be guided or influenced by the subsequent experience of the executive or of the discerned inequitable results. That is what the court said as far as the distortion. Now, then finally, the revenue said purposive interpretation should be given. Court says the principle of purposive interpretation can be applied only in a situation where the language of the statute is capable of bearing more than one construction or plain grammatical construction leads to an apparent contradiction of the underlying object of the statute. The cardinal rule of construction is the words of legislation, when precise and unambiguous, declares the legislative intent. So when the words are very clear, they show the intent. There need not be any purposive interpretation. The courts are bound to give effect to clear legislative language, even if the consequences which follow were neither contemplated nor countenanced. A mere anomaly would not be sufficient for the test of literal meaning being jettisoned. The court held the language in which section 61 and 65 are couched does not give rise to any ambiguities. It is not the case that the plain grammatical construction leads to apparent contradiction or a position of irreconcilability between two provisions in the same act. The Delhi High Court said that its conclusions are based on harmonious construction. The argument of CBIC was based on inequitable impact on domestic industry. That pertains to the policy. Court said it is a policy which cannot constitute a legitimate basis for the court to reconstruct a statutory provision. It would be wholly incorrect to recreate or reassemble section 65 so as to exclude a particular category of activity based upon the experience of its working or its perceived negative impact on domestic industry. Delhi High Court said finally CBIC is free to adopt remedial measures, but court cannot be justified in deploying principles of purposive interpretation to correct that projected and asserted anomaly. That is what finally court said and quashed the instruction given. This is a wonderful judgment. So I thought I will share with you. Thank you very much. Have a great day.